let's get ready to go. We could probably put this here. Aim that down, aim that up. Okay, how's everybody doing tonight? Let's get as close as we can here. I'm gonna crack that door just for a second. Things here. Okay, so we're gonna go over Pierson versus Ray tonight. We're gonna go over Pierson versus Ray. Fix that right there. There we go. How's everybody doing? Good to see everybody. This place is kind of in shambles right now because I'm doing a build in my truck right now. I'm doing a build in my van right now with my cousin who has the skills to do these things, and I really don't. So we're gonna go over Pierson versus Ray. I also took the time today to set up the Tenney versus Brandoff paper, and I'll send that off to you guys. So, because what I can't stand when what I really can't stand on when I read a document sometimes, I don't like it when the document has two halves to it. And so what I did today, it took a couple hours, but it's no big deal. I don't mind doing it. I actually enjoy being able to share the knowledge with you guys, and I'm getting back a ton of knowledge from you guys, by the way. So a lot of people are sending me a lot of great information. We got the Brookside people. Make sure if you guys are from Brookside that you're reaching out to me. People from Brookside, Alabama. I have a list of people now from Brookside and I tried to call today. I tried to call Brookside Police Department. I tried to call Jefferson County Sheriff's Department today. I got hung up on every time. And there were just so, like, I mean, I can show it to you guys. So I won't get too far in the woods with you guys on this, but I called today Brookside, I called the police department, I called the sheriff's department, I called City Hall, I called the mayor's office, I called every single different entity that I could call today, and I was either hung up on, or they were, or I got an answering machine that just beeped, that only beeped. So how many people are here to talk about Pierson versus Ray? How many people here are here to talk about Pierson versus Ray? Just let me know if you guys actually got a chance to watch the video today. I posted the entire oral arguments today. I posted the oral arguments today of Pierson versus Ray. I posted them today. Did anybody get to watch the Pierson versus Ray oral arguments? I did that this afternoon. I dropped it. I guess hit the #1 button. I guess that's what you're supposed to do. I don't know. I've been watching Dennis Sperling. So I've been watching Dennis Sperling's channel with Hit the #1. So now what's going to happen right now is we're going to go over Pierson versus Ray, but I want you to be prepared because I'm going to pop back and forth between Pierson versus Ray and Tenney versus Brandoff. And what I did today was I just took the time to... What I did is I just edited the case text of Tenney versus Brandoff. You guys reach over and hit your thumbs up button right down there. And where's everybody from? Is everybody from America? Are there only Americans in the room? Is there anybody here who's not American? Is anybody from California? Is anybody from New York is in the house? Is anybody there from Arizona? Is anybody in Arizona? Boise, Idaho's in the house. Australia. Hope you guys are okay. God bless you in Australia. Hope you're okay. San Diego. Yorktown, Al Yorktown is in the house. New York City, Tony, good to see you, Tony. New Zealand, one of my best friends is from New Zealand. His name's Ian. Ian's one of my best friends from New Zealand. Virginia's in the house. Good to see you, California. I do miss my home state. I've been gone for a little bit. I'm in Hawaii, Anaheim. Jersey, Florida, Cali, Oregon. Nice. Nice. Good to see everybody today. Good to see everybody. International Space Station. If you know, you guys make sure you keep on getting the message out. Keep on watching the videos. if you guys see anybody comment from Brookside, Alabama, make sure you have them reach out to me. Anybody from Brookside, I want to make sure that we try to get as many people as we can, because this is going to come down to federal lawsuits against Brookside, Alabama. And you guys make sure that we're all calling. You know what's really funny is I called that loser, the loser from I guess his name is Jim Wooten. I called Jim Wooten's office today. Jim Wooten's number is going directly from his line directly into the Jefferson County Sheriff's Department. So when you call Jim Wooten's line, when you call Jim Wooten's phone number goes directly to the Jefferson County Sheriff's Department. So I think that Jim Wooten, you guys, his name is Jim Wooten, Wooten, Jim Wooten out of there we go. See if that'll balance it out a little bit. Okay. Is that right? Is everything right? Okay. So now let's, Wooten, Jim Wooten. Jim Wooten, that's the guy. So let's jump right into Pierson, and just remember that we're gonna jump over into pages, because we're gonna read some of Tenny Brandoff today. So what I did is I just took the case text of Tenny Brandoff. I guess I don't really need to be that close to the camera. I can be on this side really and still get what I want to get out of working with you guys on this particular video. So the Tenny Brandoff right here, we're gonna jump into Tenny Brandoff quite a bit, because we're gonna come back and forth between. This is Tenny Brandoff from 1951. I will zoom into this for you guys so that we really get a clear depiction of what we're looking at. And so without waiting any longer, let's jump right into Pierson versus Ray. This is going to be your basis for qualified immunity. This is going to be your basis for your qualified immunity. Let me go like this. There we go. How's everybody? Is everybody ready to go? So grab a pencil and paper, or get your computer next to you ready to go, because I'm going to have you write something down. You guys can drop these in the comment section as we go, but there's going to be several cases here that you're going to, so, a lot of people ask me, they say, and to be honest with you, I didn't, there's a lot of people who know a lot more information than me. I'm not the smartest guy in the world. As a matter of fact, I would say I'm classically dumb, to be honest. I just am so passionate about the subject that I will read a page, I will read the same page 4 or 5 times. Tenny Brandoff, I read the pages several times each page, because I really wanted to understand the basis of how Pierson versus Ray was created. And so now when you go along, and Oyez is a great resource for the oral arguments, when you hear them mention another case, you should read that case. You should be going to Justia, to Oyez, to Case Text, to Nexus Lexis. If you can get a legal law card, you can go to LexisNexis. But this is how I became the person that I am, as far as knowing con law to the level where people call me and ask me to help them study for the California State Bar and work on con law with them. And I didn't even graduate from college. So the law doesn't require that you go to law school or you get some PhD from wherever university and you go into debt $150,000. It doesn't require that. The law requires that you understand the case law, and that you understand the jurisprudence and the stare decisis, and you understand the system of which it works in. So when you hear, and I'm actually gonna stop the tape, and we're gonna take a note, and we're gonna put it in the live notes for anybody else who's watching this. So when you see a case, like you're gonna hear a case called Monroe versus Pape, P-A-P-E, Monroe versus Pape from 1952, pretty sure. So when you hear about Monroe versus Pape, then you're going to want to take a note on that, and then you're going to want to go in and you're going to want to read the case text of Monroe versus Pape. And the case text, by the way, you're about to see it. I'll show you the actual version of case text that I have a membership for. And by the way, you don't even need a membership to case text. You can use case text without a membership. And then you read up on the cases, and then you know how they all connect with one another. You know, the case of what is it? It's versus Heisel. We're going to come across it. So let's jump right into these oral arguments, and let me just look at the comments for 1 second here. As you guys know, I can't really have a conversation and at the same time read comments because of, you know, my own personal disabilities, you know, my own personal shortcomings. You know, I'm not the smartest guy in the world. I can't do things because of my ADHD. I have, you know, I have my own difficulties like we all do. And so that's why most of the time I won't be engaged in the conversation over here. I pulled it up and I'm looking at it. And so protesters being armed, you have a right to protest. And I believe that's going to be Edwards versus South Carolina, 1962. That's what that's going to be. Someone just said you have a right to protest. So you're talking about protesting in the comments. Look up the case of Edwards versus South Carolina, 1962. 1962. So do you see what I'm saying? When you just involve yourself in reading the case text and reading the text and reading the case and listening to the oral arguments, then when someone starts talking about protests and comments over here, you can say that's Edwards versus South Carolina, 1962. And even if it's 1963 or 1961, once you give someone the breadcrumbs to follow in Hansel and Gretel, well, then they can follow it down and get to the gingerbread house. Is that what it is? Edwards versus Carolina, I'm pretty sure it's 1962. But I have dyslexia and I have ADHD and I have all blah, blah, blah. Excuses, excuses, excuses. You have no excuse for not knowing your rights. No excuse. If you don't know your rights, you don't have any rights. So now without further ado, let's jump right into this. I will shut this other computer over here so we don't get a reflection.
Versus J.L. Ray. And number 94, J.L. Ray of L versus Robert L. Pierson. Mr. Ratcliffe, Mr. Chief Justice.
1 second.
May it please the court. The complaint here alleges two causes of action. One based upon title.
Connected to Chills McNamee.
Number 79, Robert L. Pierson et al. Petitioners versus J.L. Ray. And number 94, J.L. Ray et al. versus Robert L. Pierson. Mr. Ratcliffe. Mr. Chief Justice, may it please the court. The complaint here alleged two causes of action. One based upon Title 42, Section 1983, based upon the 1871 Civil Rights Act. And the second cause of action was a common law action for false imprisonment. The defendants in each of these causes of action were the police officers and the convicting magistrate who had incarcerated the petitioners herein. Petitioners being one Negro and three white Episcopalian ministers who were arrested in the bus station in Jackson, Mississippi. At the trial, on the damage question, which is present before this court, before Judge Mize of the Southern District of Mississippi, before him and the jury, there was a verdict for the defendant. That is the respondents here. The petitioners appealed to the Fifth Circuit, and the Fifth Circuit reversed because of errors made by the Judge Mize with regard to the admission of evidence. However, in reversing, the Fifth Circuit dismissed the case against the magistrate, respondent Spencer here, and insofar as the question of damages was concerned, set forth a rule on the new trial, which indicated that if there was a finding that there was a plan and purpose to be arrested, then the petitioners here could not recover in the new trial. It was on those two issues mainly, that we came to this court, and upon our petition, certiorari, was granted by this court. They are raised in the cross petition, Your Honor, by my colleague, but that they're not raised by us. Now, very briefly, and I will try to be very brief because I'd like important questions of law and novel to this court. Very briefly, the facts are as follows. The General Convention of the Episcopal Church, the Triennial General Convention of the Episcopal Church, was to be held in September 1961 in Detroit. The petitioners here, particularly petitioner Reverend John Morris, who was the director of the Episcopal Society for Cultural and Racial Unity, thought it would be a great witness for their church to hold a prayer pilgrimage beginning in New Orleans and ending in Detroit, and on the way bearing Christian witness to factors in various communities going up generally the Mississippi Valley on the way to Detroit, with intention of stopping at places like Sewanee and Dearborn, Michigan, as well as Jackson, Mississippi. And they set out by bus from New Orleans and arrived in Jackson and spent the night on the day before the arrests were made here at Tougaloo College. There had been, of course, some publicity in the papers and the newspaper and the radio about their activities. But the next morning, when they went with tickets for a Continental Trailways bus to Chattanooga, and they had not given any publicity, and there is nothing in the record which indicates that anyone knew when they were arriving at the bus station. And the fact of the matter is the record reflects that no one was waiting for them. The police testimony is very clear on that point. They arrived quietly in taxi cabs. There were 2 police waiting on the back ramp of the bus station. The police went around the back way and met the priests as they walked through the main entrance of the bus station, past a police stanchion right in front of the entrance to the bus station, which said, "White only by order of the police." As they went into the door of the bus station, Father Jones, one of the petitioners here, heard one of the officers say, "Shall we get them now or shall we wait till later?" In any event, there were 15 priests in this group, 4 of whom are petitioners here, walked through the entrance and started toward the coffee shop a few feet inside the bus station. A few of them, of the 15, did actually get into the coffee shop, but at that point, one of the 2 police officers, either Officer Nichols or Officer Griffiths, 2 of the respondents here, halted them and made them those that come in the bus station come back, and they halted the whole group and were told to move on. At this point, one of the priests said, "We are on our way to Chattanooga. We have tickets, and we wanted to, it'd be a long trip, we wanted to have coffee or sandwich or something before we take off on our trip." The police officer said, "Move on." With no moving on, they were arrested, and not being told, and the record doesn't reflect why they were being arrested at that point, or what they were being arrested for, or why they were told to move on. But in any event, a few moments later, the respondent Ray, Deputy Chief of Police of Jackson, Mississippi, and at that time the captain of the police, came in the station and immediately walked up to these people and told them to move on, not seeking information from the other police officers. They were already under arrest. In any event, the comedy went on, and he told them to move on, and they repeated the same thing. They wanted to have the sandwich before they took off for Chattanooga, and he, at that point, not moving on, he also arrested them, and they were then taken off in the traditional Jackson paddy wagon to the jail, and where they stayed 2 days later when the case was then tried before Magistrate Spencer, who convicted them and sentenced them to the maximum sentence of 4 months in jail for the offense that they committed, as well as a fine which was put upon them. All the petitioners here remained in jail for at least 7, and Father Jones, I think, something like 17 or 18 days. The reason being that bail was coming from various communities to help bail them out, and it took at least 7 days to get bail, and more for Father Jones. In any event, after they all were released, they went on to the convention. They appealed the case. And in Mississippi, the first appellate procedure is this de novo trial. And at the de novo trial of Father Jones, the first one tried, after the prosecution's case was in, motion was made to dismiss, and the judge presiding at that level dismissed the case on the grounds there was no showing of a violation of the statute. Was there, and all the other cases were accordingly null pros. At that point, shortly thereafter, the complaint served in the case before us, and was tried, as I said, before Judge Mize. Defendant's verdict, we appealed to the Fifth Circuit as indicated. Now, the first issue that I would like to spend some time on is the...
Okay, so let's stop right here for 1 second, and let's kind of... I got the comments turned on so I can see if you guys have any questions. Do you understand what's going on? Let me just paraphrase it so that we truly understand what's going on in the case right here. You got a bunch of Episcopalian ministers who are called Freedom Riders. America was desegregated in 1954 officially by the Warren Court because Earl Warren was an authoritarian and he wanted to put black people through what's called assimilation. You guys can put that in the comments. It's called assimilation. Assimilation is what we did to the Native American Indians, And in Earl Warren's mind, he wanted to do the same thing with black people. Earl Warren was not a humanitarian. He didn't care about black people. That's not why he desegregated America. That is not at all why he desegregated America. Earl Warren was a devil in sheep's clothing, seeming as though he is the reason why Malcolm X and he is the reason why Martin Luther King Jr. said, beware of the white liberal, was because of Earl Warren. And so what's happening, what you're hearing here in Pierson Vs Ray, and we're going to get into the first issue of the legalities of Pierson Vs Ray. But what he's doing here is he's setting up the scene and explaining to you what happened in 1961. So how many years is that after desegregation? That's 7 years after desegregation. And even still in Jackson, Mississippi, this case doesn't go to trial till 1967. So that's 6 years after the men are convicted and do 4 months of hard labor. So what you're talking about are black people who are going into restaurants and bars and clubs and dentist's office and doctor's offices, and they're called freedom riders. And what they're doing is they're doing what you First Amendment auditors do. And I guess I would consider myself a First Amendment auditor as well. I'm more of a civil libertarian, but I'm definitely auditing where I can and when I can. So what's happening here is the freedom riders are going to this cafe, diner, whatever it is, to stress test their rights. In 54, it was desegregated, saying, and matter of fact, you go back to the 1866 Civil Rights Act, the 1871 Civil Rights Act, we'll be talking about later, and that defines what a citizen is. And so when you hear John F. Kennedy's 1964 Civil Rights Act say that all citizens have equal rights, he was talking about black people too. And so these people are auditing that cafe, and at that cafe or diner, whatever it is, I've never seen it, what they're doing is they put a sign up front, and the police are enforcing what they know is illegal. The police know it's illegal. It's a federal Supreme Court case. And if you cops don't know what a federal holding is, what a Supreme Court holding is, let me educate you cops. When the Supreme Court holds something, that's the supreme law of the land. The Supreme Court. So these cops have set up a sign outside of this diner and said, whites only allowed here. What do we know? That's unconstitutional because of the 1954 case of Brown versus Board of Education. So I just wanted you guys to be absolutely clear what's going on here. The cops have set up a sign, and these people are stress testing their rights, just like you do as a First Amendment auditor, just like you do.
One in which the Fifth Circuit dismissed the action against the convicting magistrate Spencer, one of the respondents herein. Now, it is our position that this was an error for many reasons, and I would like to go into that in some way. The statute, of course, 1983, the opening words are every person, so that on its face, anyone who violates
matter what you are. Hold on one second, guys. Let me. Thank you, Archangel. I appreciate that. Thank you. Are we back online here? Are we back online? It's a little frustrating, but I spent a lot of the day today preparing documents and stuff for you guys so that we could really go over the qualified immunity of Pierson versus Ray and go over Tenney versus Brandoff. I spent a long time making sure 111. Okay, so we're back. We're back. Okay. Hey, David, how are you? Okay. Okay, are we back on, guys? Okay. If we're back on, we will proceed. We will proceed. Hopefully, this is going to work. That was a little frustrating. That was a little bit frustrating. That's okay, though. So there was a couple things here that we didn't, that you guys didn't hear, and and I'm going back just a couple seconds because it's really important that you guys hear this next part, because I'm going to show you something how Tenney versus Brandoff actually creates Pierson versus Ray, and Tenney versus Brandoff is pretty disgusting when you get into the minutia, into the great detail of what Tenney versus Brandoff is. So I backed up like 15, 20 seconds, and let's keep going.
Which should be a guide to any court considering them. Prior to the well-known case decided by this court in 1951 of Tenney against Brandoff, there had only been one case interpreting this point to the best of our knowledge, and that was a case entitled Picking against the Pennsylvania Railroad, a Third Circuit case, which held in the manner that we are requesting this court to hold. That is,
Picking versus, you guys read that right there? Picking versus South Carolina Railroad. Picking versus Pennsylvania Railroad. So it's called Picking, P-I-C-K-I-N-G versus Pennsylvania Railroad. So someone type that right down in the comments, pretty please. Picking versus Pennsylvania Railroad.
there was not an immunity for a judge who violated the statute. However, Tenney against Brandoff set off a whole new line of cases, which are referred to both in the opinion of a court below and I'll refer to in my worthy opponent's brief. And in fact, I think this court has either accepted or is considering certiorari in two related cases involving a Dombrowski case and a Powers against Heisel case on related questions. Every circuit deciding the case since Tenney has decided in a manner in which we consider in error in interpreting the statute. Now, Tenney involved...
As to judicial immunity.
Yes, sir.
You're referring now only to this
I'm only referring
judicial
to
defense.
I am not concerned with any other questions, Your Honor. Yeah. Now, Tenney involved, of course, a state legislator of the state of California, and who was sued under 1983 by someone claiming that Tenney had violated his rights. Now, under Tenney, the majority decision was based upon what was considered to be the ancient immunity of legislators. And there is no other basis for that decision as set forth in the decision. Oddly enough, this, of course, reason is irrelevant, because if the 1871 Congress wanted to specifically include state legislators, the fact that there may have been an ancient history exempting legislators would be of no consequence whatsoever. However, the majority decision in Tenney is decided solely on the basis of the ancient history of immunity to state legislators. Now,
okay, so what does he mean right there? I want to read this again, and I want you guys to read this with me. Remember, our entire judicial system is based on jurisprudence, on the case previously. And the case previously is based on 15th, 16th, and 17th century common law, which is led by a monarchy or a king or a ruler. And this says, however, the majority decision in Tenney is decided on the sole basis of ancient history of immunity to state legislators. So the way you get qualified immunity for the cops in Pierson Vs Ray is when they give the legislator and the judges qualified immunity in Tenney versus Brandoff. And so when you take a look at Tenney versus Brandoff, let me open this big for you guys so you guys can see it. I'll zoom in a little tighter for you guys so you can really take a look at it. Now, let's read this together so that you guys really get a basis and an understanding of what Tenney versus Brandoff is, so you understand how it's set up. An action brought under a respondent alleging in connection with investigation. So I want to get to the meat of the story here. Petitioners are committee and the members thereof, all whom are members of the legislator. I'm sorry, where's my stick at so I can point? Held from the allegations of the complaint, it appears the petitioners were acting in a field where legislators traditionally have power to act. The privilege of legislators to be free from arrest or civil process for what they do or say in legislative proceedings has been carefully preserved in the formation of our state and national government. So just because they did it previously, then they're still getting immunity because that's the history of it. Congress did not intend to limit this privilege. Who cares what Congress intended to do? Time for change. By subjecting legislators to civil liability for acts done within the sphere of legislative activity. This privilege is not destroyed by a claim that the motives of the legislators were improper. So in other words, the privilege of immunity for legislators is not destroyed by a claim that the motive of the legislators was improper. So even if the legislators were improper in their motivations, because of the history of them getting immunity, they just get immunity. Does that make any sense to you? Is that what justice is? You understand? It all comes from Tenney. In order to find that a legislative committee's investigation has exceeded the bounds of legislative power, it must be obvious that there was an usurpation of functions exclusively vested in the judiciary or the executive. Legislative privilege deserves greater respect in a case in which the defendants are members of the legislature than where an official acting on behalf of the legislator is sued or where the legislator seeks affirmative aid to the courts to assert a privilege. And so now we get into the story of Tenney versus Brandoff, which is why I showed earlier the oral arguments of Pierson in entirety. William Brandoff brought this action in the United States District Court, alleging that he had been deprived of rights guaranteed by the Constitution. Jack Tenney and other members of a committee California legislature, the Senate Fact-Finding Committee on Un-American Activities. Do you understand that? Remember, World War II is going to end in 1945. And so then by 1949, you have this Tenney Committee. And the responsibility of the Tenney Committee is to look for un-American activities, colloquially known as the Tenney Committee. What's their job? What's their function? To look for un-American activities. Also named as a defendant are the committee Elmore E. Robinson, mayor of San Francisco. The action based on, so 43 and 47 of Title 8 is the same as Section 241 and 242. These sections are derived from the statutes in 1871. So this would be U.S. Code 18, Section 242 today. So 43 and 47, when you read that of Title 8, are now 241 and 242. I'm just letting you know the actual legality. Aimed at enforcing the 14th Amendment. And what is it exactly? What exactly is a 43, 47, or commonly called right here, commonly called a Section 18, 241, 242? Every person, not legislators and judges are not immune. Every person who under the color of any statute, ordinance, regulation, custom, or usage of any Secretary of State or territory subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof, the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured and in an action of law, suit, or equity, or other proper proceedings for redress. This doesn't say some people. This says every person who violates your constitutional rights. Section provides civil remedies to or more persons who may conspire to deprive another of constitutional rights. If two or more persons in any state or territory conspire to go in, disguise, or on the highway or in the premises of another for the purpose of depriving either directly or indirectly any person or class of persons of the equal protection of laws or of equal privileges and immunities under laws, or for the purpose of preventing or hindering the constitutional authority of any state or territory, or securing the person within such state or territory the equal protection of laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner towards or in favor of the election, right? Blah, 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 right? And it says, so you see what it keeps saying though? I want you to show you something. Any lawfully qualified person, the president, anybody who's in office can be held liable. Legislator, judge, it doesn't matter. Tenney versus Brandoff is fourth. In one or more persons engaged therein do cause harm. And so this goes on and on, but I want to get right to the story of Tenney. I want to get into it right here. The petition charged that the committee had used Brandoff as a tool in order to smear Congressman Frank R. Havener as a communist, when he was a candidate for mayor of San Francisco in 1947. So Brandoff is being accused of being a conspirator to smear Congressman Frank Havener as a communist when he was running for mayor of San Francisco in 1947. Remember that World War II ended in 45, and there was this big kick to make sure nobody was communist or un-American. That's what the Tenney Committee is. And the threat of the Republican machine in San Francisco and the campaign manager of Elmore E. Robertson, who ended up winning the mayor of San Francisco, Frank Havener's opponent, conspired with the Tenney Committee to this end. In view of the conflict between this petition and the evidence previously given by Brandoff, the committee asked the local prosecuting officials to institute criminal proceedings against him. The committee also summoned Brandoff to appear before them at a hearing held January 29th. Testimony was there taken from the mayor of San Francisco, allegedly a member of the conspiracy. So now what are they doing? They're calling Brandoff in front of a kangaroo court. The committee is acting on the behalf of anybody who's un-American. So that's vague, isn't it? It can be anything. Anybody can be un-American. Just depends on what you think is un-American. It's up to you. The plaintiff appeared, so Brandoff appeared with counsel, but refused to give testimony. And why did he refuse to give testimony? Because when you're being accused of a crime, you do not speak. You do not speak when you're being accused of a crime. So Brandoff appears with counsel, but he won't give testimony. He was prosecuted for contempt in the state courts upon the jury's failure to reach a verdict. This prosecution was dropped. After Brandoff refused to testify, the chairman quoted testimony given by Brandoff at prior hearings. So now he's being prosecuted for what he said at previous hearings. The chairman also read into the record a statement concerning an alleged criminal record of Brandoff, a newspaper article denying the truth of his charges. So what the media printed, so people can print anything they want about you. They can say that you said anything they want, denying the truth of his charges. So the chairman of this particular committee is saying that there's a truth to his charges and a denial by the committee's counsel, who was absent, that Brandoff's charges were true. Like I just said, they're saying that his charges are true. And this is the basis that gives government immunity for the stuff they do to us. Brandoff alleges that the January 29th hearing was not held for a legislative purpose, because it's a kangaroo court, but was designed to intimidate and silence plaintiff and deter and prevent him from effectively exercising his constitutional rights of free speech, and to petition the legislator for redress of grievances, and also to deprive him of the equal protection of law, due process of law, and of the enjoyment of the equal privileges and immunities as a citizen defined in the 1866 Civil Rights Act of the United States under the law, and so did intimidate, silence, deter, and prevent and deprive the plaintiff of his constitutional rights. Damages of $10,000 were asked for legal counsel, traveling, hotel accommodations, and other matters pertaining to the necessary to his defense in the contempt proceedings arising out of the committee's. So he's charged with contempt. The plaintiff also asked for punitive damages, punishing damages for what they've done wrong. The action was dismissed without opinion by the district judge. The Court of Appeals for the 9th District held, however, that the complaint stated a cause of action against the committee, against the Tenney Committee, because the Tenney Committee is an un-American committee, which there's no end to that, and its members. We brought the case here because important issues are raised concerning the right of individuals and the power of state legislators. The Court of Appeals affirmed the dismissal as to Robinson on the ground that he was not acting under the color of law and that the complaint did not show him to be a member of a conspiracy. Robinson was Elmer's campaign manager. We have denied a petition to review this decision. We are again faced with the Reconstruction legislation which caused the court such concern in Screws versus United States. But the time we do not have to wrestle with far-reaching questions of constitutionality. But this time we do not have the time. We don't have the time. We do not have to wrestle with far-reaching questions of constitutionality. It's not a far-reaching question, or even of construction. We think it's clear that the legislation on which action is founded does not impose liability on the facts before us once they are related to the presuppositions of our political history. The privilege of legislators to be free from an arrest or civil process for what they do or say in legislative proceedings has taproots. So a deep history, deeply rooted in the parliamentary struggles of the 16th and 17th centuries. Do you understand it? The legislators have gotten qualified immunity since the 16th and 17th centuries. That's why I paused here to read this, so that you guys could understand that just because it's old from the 16th and 17th centuries, that we should continue to give legislators immunities when they do things that are messed up, that are unconstitutional. As Parliament achieved increasing independence from the Crown, its statements of privilege grew stronger. I don't care. I don't give a damn. In 1523, our Constitution, I'm trying to get more mad, okay? In 1523, Sir Robert Moore could make only a tentative claim. Roper, Life of Sir Thomas More in More's Utopia. After a long and bitter struggle, Parliament finally laid out the ghosts of Charles I, who had prosecuted Sir John Eliot and others for seditious speeches in Parliament. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. Did you see that? Did you just hear that? Did you just hear what they just said? Did you just... That no matter what they do, if they have been elected to the Parliament, if they've been appointed to the Parliament, then they ought not to be impeached or questioned. It's your job to question public officials. It is your job to take these people on. It is American to question if your constitutional rights are being infringed upon. This is disgusting. That's why I stopped it here, so that you guys would understand this is the most nasty, disgusting thing you could ever understand from. So I kind of looped you. I told you we'd be talking about Pierson versus Ray. I released the video earlier today. The real conversation is Tenney versus Brandoff. That's the real, just like Terry versus Ohio isn't the real conversation. It's not. The real conversation is Carroll versus United States of 1925. That's the real conversation. Freedom of speech and action in the legislature was taken as a matter of course by those who served the colonies from the crown and founded our nation. So because the actions of the legislator during the time of the Declaration of Independence, during when we first took the America, right? It was deemed so essential for representatives of the people that it was written into Articles of Confederation and later into the Constitution. Article 5 of the Articles of Confederation is quite close to the English Bill of Rights. Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress. I don't care. I don't give a damn what this says. I don't care about the history. I do not want legislators to be able to roll over our constitutional rights because they did it in the 1500s. I don't want it. I don't want it. For any speech or debate in either house shall not be questioned in any other place. What the hell are you talking about? The reason for the privilege is clear. It was well summarized by James Wilson, an influential member of Committee of Detail, which was responsible for the provisions in the federal Constitution. In order to enable and encourage a representative of the public to discharge his public trust with firmness and success, it is indispensably necessary that he should enjoy the fullest liberty of speech and that he should be protected from the resentment of everyone, however powerful, to whom the exercise of that liberty may occasionally offense. It's absolutely ridiculous. The provision in the United States Constitution was a reflection of political principles already firmly established in the states. 3 state constitutions adopted before the federal Constitution specifically protected the privilege. The Maryland Declaration of Rights, November 3rd, 1776, provided that the freedom of speech and debates or proceedings in the legislature ought not to be impeached in any other court or judicature. The Massachusetts Constitution of 1780, what are we talking about here? Do you think maybe we've advanced past 76, and maybe we're a little further more advanced as a species from 1780? I don't give a damn. I don't give a flying unicorn what Maryland thought in 1776. I don't care. I don't care if they thought it would be best that legislators were given absolute immunity. I don't care what they think. I don't give a damn. I really, really don't. And then it just goes on to continue to repeat the same thing over and over, but to support the rights of the people, enabling representatives to execute the function of their office without fear of prosecution. Without fear of prosecution, as long as you don't violate someone's constitutional rights. You don't have to fear prosecution if you're not violating someone's civil rights. Why is that so hard to understand? You don't get absolute blanket immunity. If you violate someone's civil rights, you need to be held accountable. Under a 1983, or back then it was Section 43 and 47 of a Section 8. I will confine to delivering an opinion. To uttering a speech or haranguing in debate, but will extend it to the giving of a vote, to the making of a written report, or every other act of resulting. So I want to get into the actual case for you guys today, because a lot of this is minutia. I cut and paste this whole thing. I put it into pages because on the case text, just so you know, they have it split and it's not, you can't blow it up. And so I had to take the time today to get this laid out for you guys. In New York, the Bill of Rights passed. The legislator in 1787 that the freedom of speech and debates and proceedings in the Senate and Assembly shall not be impeached or questioned in any court or place. What does that mean? If you violate someone's civil rights, they should be impeached, and those you should look at having a hearing in another place. You shouldn't get absolute immunity just because you're a legislator. It's absolutely ridiculous. It's stupidity. So let me get into the actual case now. I'm going to skip through this stuff. What they're doing right here is they're giving examples of all the different states of where people said, oh yeah, everybody, see, they're saying everybody agrees in the 1700s and the 1800s that legislators get absolute immunity. And why are they saying that? Because this is jurisprudence. This is what our legal theory is based on, is what the case precedent is based upon. So the case coming forward is the stare decisis. You understand that? So the jurisprudence is the legal theory that we're gonna base it on cases previously. The stare decisis is Terry v. Ohio when you come forward in time. Okay. So I want to get to the story here. I'm just going to scroll down. House of Commons. I mean, this is just such crap. Okay, so now remember, we talk about Mr. Justice Black, Hugo Black, member of the KKK. So I want you guys to understand something. He's been a piece of garbage since he got on the court. You have no idea. And he's on the court from 1937 until 1971 or something like that. He's on the court for 35 years. Hugo Black is 72, I think he retires. Hugo Black he concurs that legislators should get absolute immunity, and so should judges, or to the hazard of judgment against them upon a jury's speculation as to motives. The holding of this court in Fletcher versus Peck was not consistent with our scheme of government for a court to inquire into the motives of legislators. Well, the motive of legislators certainly matters, but your subjective intent does not matter. What matters is if you violated someone's constitutional rights. I don't give a damn what your motives are. I don't care what a cop thinks in his head. I care how you violate someone's rights. That's what matters. That's what truly, truly matters. Let me come back a little bit here. So this is going to say right here, Brandoff indicated that the evidence previously given to him by the committee was false and that he raised serious charges concerning the work of a committee investigating a problem within legislative concern. The committee was entitled to assert a right to call the plaintiff before it and examine him. It is the proper duty of a representative body to look diligently into every affair of government and to talk much about what it sees. It is meant to be the eyes and the voice and to embody the wisdom and will of its constituents. Unless Congress have and use means of acquainting itself with the acts and the disposition of the administrative agents of the government, the country must be helpless to learn how it is being served. And unless Congress both scrutinize these things and sift them by every form of discussion, the country must remain in embarrassing, cripple ignorance of the very affairs which is most important that it should understand and direct. The informing function of Congress should be preferred even to its legislative function. It should be noted that this case in which the defendants are members of a legislature, legislative privilege in such a case deserves greater respect than where an official acting on behalf of the legislator is sued or the legislator seeks the affirmative aid of the courts to assert a privilege. In Kilbourne v. Thompson's Supreme Court, the court allowed a judgment against the sergeant at arms, but found that one could not be entered against the defendant members of the House because they're legislators. We have only considered the scope of the privilege as applied to the facts of the present case. Do you guys follow what I'm saying here? I mean, are you getting what I'm putting down, Brown? I hope you guys are truly understanding what this is saying here. The court holds that civil rights statutes were not intended to make legislators personally liable for damages to a witness injured by a committee exercising its legislative power. There it is, right there. There it is. These people are interpreting your rights for you right here. You're not smart enough to read your rights. You're dumb. The court holds that the civil rights statutes were the statutes. First Amendment, Second Amendment, those are statutes. Those are listed statutes. Were not intended to make legislators personally liable for damages to a witness, you, injured by a committee, the Tenney Committee, exercising legislative power. So that means the state has absolute power. The state has absolute power. And if you get hurt or you're injured, it doesn't matter because you can't interrupt a committee exercising its legislative power. Do you see how disgusting it is? This is the result reached by a reference to the long-standing and wise tradition that legislators are immune from legal responsibility for their intra-legislative statements and activities. No! Hell freaking no! No! My God. The court's opinion also points out in Kilbourne v. Thompson held legislative immunity to some limit, to have some limit. Well, what is it? And today's decisions indicates that there is a point at which a legislator's conduct so far exceeds the bounds of legislative power that he may be held personally liable in a suit brought against the Civil Rights Act. I substantively agree with the court's reasoning and its conclusion, but since this is a difficult case for me, I think it is important to emphasize what we do not decide, said the judge. Said the Supreme Court judge is saying this. He's saying, I think it's important that, I understand all this, but we shouldn't get involved. No, dude, you are reading that our civil rights are not important, that legislative committee trumps our civil rights, and this judge right here, Mr. Justice Black, Hugo Black, he says that he shouldn't get involved. He's using it's called judicial restraint. If someone wants to type it down there. So that's what it's called. It's called judicial restraint. The judgment of the Court of Appeals is reversed and that of the district court affirmed. Just ridiculous. Just ridiculous. It's just ridiculous. It's just horrifically bad. It is not held that the validity of legislative action is coextensive with the personal immunities of the legislators. That is to say, the holding that the chairman and the other members of his committee cannot be sued. The members of his committee cannot be sued in this case is not a holding that their alleged persecution of Brandoff is legal conduct. Indeed, as I understand the decision, there is still much room for challenge to the committee's action, but you can't be held liable for civil rights violations, so what does it matter? Thus, for example, in any proceedings instituted by the Tenney Committee to fine or imprison Brandoff on perjury, contempt, or other charges, he would certainly be able to defend himself on the ground that the resolution creating the committee or committee's actions under it were unconstitutional and void. So there's a caveat there. In this connection, it is not out of place to observe that the resolution creating the committee is so broadly drawn that grave doubts are raised as to whether the committee could constitutionally exercise all of its powers purported bestowed on it. In part, the resolution directs the committee to ascertain all facts relating to the activities of persons and groups known by suspected to be all facts relating to the activities of persons and groups known or suspected to be dominated or controlled by a foreign power, anything un-American, and who owe allegiance thereto because of religious, racial, political, ideological, philosophical, or other ties, including but not limited to the influence upon all such persons and groups of education, economic circumstances, social positionings, fraternal or casual associations, living standard, race, religion, political ancestry, and the activities of paid provocation. Okay, so this is going to keep going here, and I'm going to come right down here. Let's take a look at Mr. Douglas's dissent in Tenney. Let's take a look at Mr. Douglas's dissent. So what are we looking at here? So what you're hearing right here is you're hearing that the judges, because, and you're going to hear Hugo Black in the oral arguments coming up. I don't want to ruin it for you if you guys didn't see them already today. But what you're going to hear here is that in Douglas's, you know what, let's watch a little bit more of the oral arguments, and then we're going to come back to Douglas's to William O. Douglas's dissent, and he was the lone dissenter in Tenney versus Brandoff, just so you know. So he was the lone dissenter.
There were at least two other ways in which that case could have been decided coming to the same conclusion, which would have, however, been more accurately a reflection of the law. And I would like to dwell on those for a moment. The first one, of course, concerns the legislative history of 1983. When Congressman Schellenberger of Ohio introduced the legislation we are concerned with in the House of Representatives in 1871, he made the following comment, and I read from the Congressional Globe Appendix of March 28, 1871, 42nd Congress, first session. He said as follows: "My first inquiry is as to the warrant which we have for enacting such a section as this. The model for it will be found in the second section of the Act of 1809, 1866. I may interpolate, those are the sections of Title 18, 241 and 242, which have been considered by this court in Price, for example, U.S. against Price, for example. That section provides a criminal proceeding in identically the same case as this one provides a civil remedy." Now, that being so, if the majority opinion in Tenney had followed that thought along and would have turned to Senator Trumbull's explanation in the Congressional Globe of April 4, 1866, when he replied to the veto by the then President Johnson of the 1866 Act, titled what is now titled 18-241 and 242, President Johnson referred specifically to the point that came up in Tenney against Brandoff. And what does he say? Who is to be, and I quote from page 1758 of the Act of the Congressional Globe of April 4, 1866. Who is to be punished? Is the law to be punished? Are the men who make the law to be punished? Is that the language of the bill? Not at all. If any person under color of any law shall subject another to the deprivation of a right to which he is entitled, he is to be punished. The person who under the color of the law does the act, not the men who made the law. And he goes on in that way. In other words, what he's saying very specifically is that both from the point of view of the intent of the Congress of that period and from the point of view of the analysis of the words of the statute, state legislators were immune under both Title 18-240, what is now Title 18-241, and, of course, under Title 42, 1983. In other words, state legislators are to be immune. But what does he say about judges? In other words, he makes the very distinction that we are trying to make in this particular case. And because, I might interpolate again, President Johnson, when he vetoed this 1860...
So President Johnson vetoed the 13th Amendment and was he still president in the 14th Amendment? And he also vetoed the 1866 Civil Rights Act. They tried to impeach President Johnson. He is the worst president in the history of America, and he tried to veto the 1866 Civil Rights Act. He was 2/3 of Congress outvoted him.
Two of the reasons specifically given by him for his veto concerned the immunity of legislators and the alleged denial of the immunity of legislators and the alleged denial of immunity of judges. Now,
so remember, they're passing the 1866 Civil Rights Act that is going to give rights to black people, but what do? They pack inside the 1866 Civil Rights Act a little bit of pork that says legislators get immunity. So the legislators are going to outvote Johnson on 2/3 of a majority, but the reason why Johnson was going to veto the bill was because it gave legislators immunity. But everybody wanted the 1866 Civil Rights Act to pass. Everybody wanted that to happen. All of America wanted it to happen. So the legislators knew if they put a little pork inside the act that Johnson was going to veto it anyway. Johnson was going to veto the 1866 Civil Rights Act anyway. He just puts in there something that's going to be palpable for America.
Seen Senator Trumbull, who replied to President Johnson as to what he said about legislators. Now, this is what he said about judges. But it is said that under this provision, judges of the courts and ministerial offices who are engaged in the execution of any such statutes may be punished. And that is made an objection to this bill, referring to this president's veto. I admit that a ministerial officer or a judge, if he acts corruptly or viciously in the execution or under color of any illegal act, may be and ought to be punished. But if he acted innocently, the judge would not be punished.
Okay, now we're talking about Judge Spencer here. Judge Spencer's not a full-time judge, he's a part-time judge. So that means half of the week he's not at work, right? So did he collude with the police chief of Jackson, Mississippi? I think that he probably did. That would be my guess. I don't know that for a fact. But so now he's saying here that if the judge should be punished, that's what this case is about. Pierson versus Ray is about the magistrate named Spencer who should be punished for unlawfully putting these guys in jail for 4 months for seriously enforcing segregation laws that the police put a sign out in front for.
And further on, a judge who acted innocently and not viciously or oppressively would never be convicted under this act.
But he didn't act innocently, he acted oppressively.
Is that what you're contending here? Are you contending, Mr. Reichman, are you contending that the judge here acted corruptly?
Yes.
We are contending, Your Honor, that the judge here knowingly and willfully as our complaint alleges in paragraph 22 on page 5 of the record, that the judge, as far as the judge is concerned, convicted and deprived the petitioners of rights, privileges, immunities, etc., for the sole purpose of enforcing the segregation laws, customs, policies, and usages of the state of Mississippi.
You contend that that's corrupt?
I would contend that
that's corrupt.
What is considered to be a violation, what we consider to be a violation of the statute, deliberately imprisoning someone without any evidence in the record, and that is
not supported by that quotation, is it, that you just read?
I'm sorry, sir.
It's not supported by the quotation that you just read. Your position is not supported by the quotation that you just read.
I would not accept that, Your Honor.
That's what I'd like to know. Just
well, I would say that...
Square your position with that.
Let me get back to my quotation. What Senator Trumbull has said here, first of all, because we acted innocently, the judge would not be punished, and we don't dispute, we accept that, of course. And
your problem is what is innocent.
What is innocent? But we also said, if he acts corruptly or viciously, now viciously is not a word of art, the common parlance, but I would certainly think that that would apply to a judge who, without evidence, convicted and incarcerated people, knowing there was no evidence and this is based upon not only what I say about the case and what the complaint says about the case, but the fact that on the first appellate level, the judge who tried the case dismissed on the prosecution's evidence because he said there was no evidence to show a violation of the statute. And we say the record reflects, though that is not important from the purposes of the position we're taking here in this case, that they were convicted because that sign outside the bus station said that anyone who entered that bus station who was Negro was in violation of the law, because that sign said white only by order of the police. Now, it's hard to conceive of what that means except in terms of anyone other than a white person who enters, or who whites and Negroes who enter together are in violation, and that's why they're arrested, because the testimony of the police here says these petitioners did absolutely no act which could be remotely considered wrong. And unlike the Adderley case, these people had a right to be here. There was no question they have a right to be in a bus station quietly and peacefully with tickets in their hands about to go off to Chattanooga. I mean, whatever the merits of an Adderley type of situation, they don't apply here at all, because these people had a public right to be there. And they were asked to leave, not for anything they did, but because that sign outside the door of the station did not permit them to enter the station.
Okay, now, First Amendment auditors. Now put that into respect with what you do as a First Amendment auditor. The sign says no filming in here. Do you have a First Amendment right to film? Yes, you do. The sign says you can't go in there without showing your ID. Do you have a constitutional right to walk into that building that's a federally or state funded building and not show your ID? Yes, you do. So what happens in this case, I'm not telling any secrets here. The judges are going to rule in favor of the cops and give the cops qualified immunity for arresting a bunch of people and enforcing segregation laws, and say, well, they thought they were doing the right thing. Do you think they thought they were doing the right thing? Is that what you think? If you're an auditor and you go out and you film, this is exactly what you deal with every day. These black people were stress testing their rights. And then when their rights were violated, the unelected Supreme Court screws us all. It screws us all. And now today, what are we seeing? White kids, Mexican kids, Asian kids, adults, your brother, your lover, your best friend, your cousin, your sister, your brother. Everybody now is put under the same brand that we allowed this to happen to black people. Our ancestors allowed it. I mean, listen, if you're poor, like my family was poor, we didn't allow it to happen. We didn't have a voice. We didn't have any money. There was no money, no power. That's just how it works. And so what you're seeing here is people who stress tested their rights were arrested, and then the government that's supposed to uphold the social contract of constitutionality, that the reason we adhere to this contract is because we agree not to be a bunch of savages if you just enforce the Constitution and the Bill of Rights properly. And they didn't do it. This is exactly what auditors go through today. I could literally blow up. It makes me so mad. I mean, I did this all day today, worked on these documents all day today. It still makes me so mad. I'm listening to it now. It makes me so upset. How could it not? I'm an American. I'm supposed to be free, and I'm not. And the people who are appointed to protect us so they don't have to go through a political process are appointed by the most elite rich people, and they do the bidding of the most elite rich people.
He had jurisdiction. The judge had jurisdiction, did he not?
Yes, no question. They were charged under a Mississippi statute, disorderly conduct statute. So that, in that sense, he had jurisdiction, of course, no question. But we think that the intent of the Congress of 1871, from reading the Congressional Globe of that time, is so carefully drawn against the sham justice that was perpetrated
the sham justice
from 1866 through the period of 1871, that the very kind of conduct that is concerned in this case is the kind of conduct the 1871 Congress was concerned about. They were concerned about the phony justice, the sham justice, that the police who arrest and the judges who convict when there is no evidence of any wrongdoing.
And there was no evidence of wrongdoing. They went to the bus terminal. When the police got there aggressive with them, they said the Lord's Prayer.
Because we the distinction that we draw, and we think that Senator Trumbull draws that distinction perhaps better than we can. We just think the distinction is that when a judge does it knowingly to perpetuate an illegal custom such as segregation, then he would be liable. But if he makes a mere error of judgment or he's unacquainted with the law, that would not be any violation of 1983. We're not questioning his right to continue to make errors of judgment. We do question the right to sit, for example, to take a case which I think might lay out the situation. We do question the right of a judge to meet with hoodlums the night before he knows he's going to try a case and tell the hoodlums, okay, fellas, I'm going to throw the book at these guys tomorrow morning when I try them. That's the kind of case we're talking about. And the decision of the Fifth Circuit and of the other circuits, if upheld, do not permit 1983 to cover a judge under those circumstances. Now,
listen to this. Listen to
Every
this.
case that has come since Tenney against Brandoff, even though Tenney was a state legislative case, every case that has been decided by the circuit courts, and there have been several since then, have decided solely on the basis of Tenney. Even though Tenney refers to a state legislator, those cases which refer to judges are given the decision in the same manner as if they have had the application to the Tenney doctrine. So Tenney has, in a sense, if you permit me to say so, led the courts astray by an improper analysis of the statutes of 1871, 1866. It is our position that if Tenney had been decided on the basis of the legislative history and the analysis of the words of the statute, the other court would not have made the mistake. As a matter of fact, Judge Magruder of the First Circuit in Francis against Crafts, which has been referred to by the court below and by our worthy opponents, is a typical case where Judge Magruder in that decision says the statute is very broad, and I am very grateful that the Supreme Court has decided Tenney against Brandoff because, in effect, it takes me off the hook. And this is precisely what Judge Magruder, who is a very fine judge, has said in a case involving a judge in Massachusetts. So that the trouble has stemmed from what the courts have decided in Tenney. Now, Tenney, I would hope that Tenney would be reconsidered in terms of not the decision, because the decision is correct in light of the statutory history, but it is wrong in terms of the reason. If the right reason is given, then all the other cases that are decided after Tenney become meaningless. And this court then is considering not only de novo from the point of view of an issue that has of the liability of a judge under this statute, but is not faced with the question of decisions made by the lower courts. To the contrary, there is only one decision which has any meaning, and that's Picking against Pennsylvania Railroad. Oddly enough, not one of the cases, with the exception of Bowers against Heisel, which I believe is submitted a petition for certiorari and was only decided a couple of months ago by the Third Circuit, not one of the cases following Tenney...
Is that the one about prosecutor in New Jersey?
New Jersey State Prosecutor, yes. That's the only one of the cases which even makes a brushing reference to the legislative history.
Immunity was extended there, too.
By the Third Circuit, Your Honor. And the Third Circuit there, in substance, said that it was overruling its prior decision in Picking against the Pennsylvania Railroad. Though one was a judge, the other was a prosecutor, and perhaps they might come to different conclusions under the same statute.
Well, didn't the Third Circuit hold there that the prosecutor was entitled to immunity because the judge was entitled to immunity?
Yes, as a matter of fact, that was precisely that reason. That was part of the judicial process.
The prosecutor, does the Third Circuit hold that the prosecutor is entitled to immunity because the judge has decided it?
Yes, as a matter of fact,
it's precisely that reason.
Process, and the prosecutor was part of the process and ought to be immune as a judge. But even there, the court sat on banc in Bowers against Heisel, and there were 4 opinions, either concurring specifically only in the result, and specifically saying that they were not going to go into the question of the legislative history, and 2 that rejected They rejected the decision because the legislative history was to the contrary in Bowers against Heisel. In fact, Judge Biggs of the Third Circuit has what we think is the proper analysis of the statute and goes into the legislative history in some detail, whereas the majority of the court there gives in a footnote a brushing reference to part of the legislative history, ignores most of it, and ignores the result of all and says we're deciding the case on the basis of Tenney against Brandoff. Now, with that kind of record, we think that there is nothing in the legislative history here, nor in the word of the statute, which sustains the immunity of judges. We think that from what we have said in our brief, that it was clearly the intention of the 1871 and the 1866 Congresses in passing these two complementary statutes, that is the Criminal Act under Title 18 and the Civil Act under Title 42, clearly, unmistakably intended to include judges. And the proof of it, we say, is in the fact that persons on both sides of the debate in the halls of Congress acknowledged this was so. They may have disagreed with the virtue or the wisdom of it, but they both agreed. They both agreed that judges were liable if they committed a violation of the Act, in the terms of Senator Trumbull, were not immune.
Okay, before we get into what these guys are going to do, these judges are going to lose their mind right here, and they're going to all question whether or not judges can be held liable for violating your constitutional rights. I want to touch just really briefly here on something that was said a moment ago. I want you guys to follow me here. Let me grab my stick because my fat fingers won't work. So I'm going to show you guys something. Now, we rely on Marbury versus Madison from 1803 in the regard that when something is held, something is unconstitutional, and the only way I can really do it is just to show you is, let me just show you guys this. Okay. So what happens? Let's just go over a couple. Plessy versus Ferguson, I'm so sorry, right here in 1896. It's going to take 50 years, 60 years before Brown versus Board of Education is going to overrule that. It's going to end, Plessy's going to be overruled by Brown versus Board of Education. And so what this guy is, and I can give you another one, Pace versus Alabama, that's going to criminalize interracial relationships. Pace versus Alabama is going to be overruled by the 1967 holding of Loving versus Virginia. You see, of Loving versus Virginia. And so what's going to happen in Loving versus Virginia is they're going to say it's not unconstitutional for you to marry or date someone outside of your race. But again, it's going to take from 1883 here in Pace versus Alabama before we get to Loving versus Virginia in 1967. And so what this lawyer is saying is he's saying, look, the 1866 Civil Rights Act, the 1866 Civil Rights Act, and the 1871 Enforcement Act, which is also called the KKK Act, they got it wrong. And how many years is it? In 1951. They got it wrong in 1951 in Tenney versus Brandoff. And the lawyer is telling the judges, he's saying, look, if you go back to the 1866 Civil Rights Act, the way it was interpreted in 1951 is incorrect. And now it's time for you guys, for this court here, for the Warren Court, to change that. Just like these courts did. Just like I showed you. Pace versus Alabama is created in 1883 by the Waite Court. Well, then Loving versus Virginia in 1967 is going to be overruled by the Warren Court. So he's telling the court, it's time for you to change Tenney versus Brandoff from 1951, and he's reading them the statute from 1866 and saying it says all persons, it says all people who violate your civil rights, not just some, all people who violate your civil rights according to the 1866 Civil Rights Act, which brings us to Section 18, Section 242 and 241, which creates those things. He's telling the judges, it's time for you guys to change these things. Remember, Cruikshank versus the United States in 1876 isn't going to be overruled until the 1964 Civil Rights Act. You understand that? So he's telling these judges, it's time for you guys to fix these things. That's what he's saying. He's literally explaining to them that it's time for you guys. We can keep going. Reese versus the United States in 1876 is going to be overruled by the 1965 Civil Rights Act. He's telling them it's time for change. It's time for you guys to lead. It's time for the Warren Court to take the ball and realize that the court in 1951, the 1951, the Vinson Court, was incorrect in their assessment and determination of what the 1866 Civil Rights Act actually said and meant. It didn't say that some people could be held liable for violating your civil rights. It said all people. It said any and all people who violate your civil rights can be held liable under a 1983 civil rights violation. He's telling those stupid bastards, he's telling them, fix it. Jesus Christ. So annoying. So annoying. He's explaining it to them. He's explaining to these people how it's what's supposed to happen. He's literally laying it out for them. And instead of them having a modicum of decency, instead of them having a simple morsel of understanding of supposed to be these Ivy League educated elitists, instead, listen to what they say when he starts, I'm frothing at the mouth. Hold on. Now, instead of that, right? Now listen to when they say, well, what about judges? What about judges? Are judges immune? That's what they're going to say right here. And listen to what these shallow, elitist, entitled pieces of appointed garbage. Listen to what they say. Listen to what they say. Listen to this. You think you're disgusted now? Listen to what Hugo Black says.
It's your argument that every judge who turns somebody loose can be sued and has no immunity?
No, Your Honor, I would say that the only...
Is your argument, Hugo Black asked this, they light him up here, there's Hugo Black right there, member of the KKK. Is your argument that every judge who's turned somebody loose can be sued and has no immunity? That's not at all what he's saying, Hugo, you uneducated goon. That's not what he's saying at all. He's saying if...
Can be sued and has no immunity?
No, Your Honor, I would say that the only judge who is liable is one who convicts with not intending to deprive him of...
All of them could be sued for it, and you'd have to prove his motive?
Yes, Your Honor, that would be true.
That's your argument. Every judge who tries a person in the United States under this act can be prosecuted on the basis of that act. He is convicted of a crime.
On the 1866 Act, if he was shown to be violative of the Act, yes. We say that there was no immunity by the virtue of the office. And that if he violated the Act, yes, he would be liable, or if he, in a civil suit for damages, liable for damages, if we're shown and proved a violation of the Act. It isn't, I mean, of course, people can be sued and improperly sued, but I would assume that there are lots of people who hold important positions in the United States who could be sued.
What about the appellate court judges?
Well, first of all, it doesn't apply to federal judges. The federal judges are exempt by the terms of the statute. It only applies under the color of state law.
I assume it could apply to federal judges.
I don't see how it could, Your Honor. I don't see how it could under the terms of the statute. It does not apply only someone who acts under the color of state law.
Well, would that get the Supreme Court judges of the states?
Well, would that apply to the Supreme Court judges of the states? That's what Hugo Black is worried about. He's not worried about what's happened in the case. He's concerned about his own skin. That's all he cares about.
I suppose theoretically it could.
Theoretically?
Yes.
Actually, doesn't it?
Well, actually in the sense that, yes, they could be sued.
So why would state Supreme Court judges be immune from civil rights violations? Why would they be immune? How come? Why would we allow state Supreme Court judges to be immune from prosecution if they violate someone's civil rights? Why? Why? Of course, they could all be held liable under 1983.
Yes, and
they'd have to try a question of evidence as to how guilty they thought the man was.
that would be so. And but I think that I think that is the correct interpretation of the statute. There are lots of people. Take a surgeon who holds a person's life in his hands every time he operates on someone has no immunity, and if a judge acts corruptly or viciously, when there is no evidence and with a deliberate intent to deprive somebody of a right that he is entitled to, I can see no reason why a judge should be put in a position that a surgeon is not.
There are a few defendants who have been convicted who didn't think they were deprived of the right corruptly and brutally by the judge.
Well, that may be true, but in the case before us, Your Honor, that isn't the facts. The fact is at the first appellate level, the case was dismissed because there was no evidence to show a violation of the statute in the first place. And whatever there may be in other situations, we are saying that there should be no rule which grants an automatic immunity. We say there is only... sorry, sir.
My questions do not mean that I'm saying that you're wrong, but it seems to me like that's precisely the correct statement that you made as to the consequences of your third argument.
And Your Honor is correct. That those are possible consequences of the argument I make, and I would have to face that, good or bad.
What you've just said is narrower than the position reflected by your complaint. As I read in your complaint, does not even allege any motive.
Well, it does to this extent.
Wait a minute. Go back. Read it again. Well, what you just said is narrowed, and the position reflected by your complaint, as I read it, your complaint doesn't even allege any motive in part of the judge. These men were locked up for going into a restaurant. The judge is upholding racial segregation that these same men passed in Brown versus Board of Education that they ended. That's how big of hypocrites these guys are. That's how much of a fraud the Supreme Court is. That's how fake and fraudulent they are because they're not held accountable by the people. They're not elected. We can't, there should be a mark for impeaching judges on every single year, on every single ballot, if we believe they didn't hold up the constitutionality of our rights. And here he says it doesn't even allege the motive in the part of the judge. The motive in the part of the judge was to punish those 15 black men for going into a whites-only restaurant that this court said was unconstitutional. What the hell is Abe Fortas talking about? He voted for it.
Does not even allege any motive.
Well, it does to this extent. I'm sorry, I shouldn't interrupt.
It does not allege any motive on the part of the judge.
Well,
it says that these people were convicted in violation of their civil rights for the sole purpose of enforcing segregation laws.
So then the judge is enforcing racism. So the motive of the judge is to enforce racism. Are you stupid, Abe? Are you stupid? Are you dumb as you burn in hell? As he's burning in hell right this minute. Are you dumb, Abe? Were you a dumb bastard or not? Yes, you were. You were dumb and slow, and you talk slow, and you are a moron.
You don't have any allegation in here about corruption or corrupt motives or vicious purpose or anything of the sort?
Vicious purpose? Have you been to jail? Have you been to jail for one day? Every day is a week. Every week is a month. Every month is a year. And he forced them into 4 months of hard labor. Nothing vicious about that, though. They just went to a dungeon. That's all.
Well, I'm sorry, but I would think that if a judge convicts somebody for the sole purpose of enforcing segregation law or custom, that spells out the violation.
You allege here that a state judge convicted a person for the sole purpose of enforcing the segregation laws, customs, policies, and usages of the state of Mississippi.
That's right.
Usually state judges are kind of supposed to do that unless there's a supervening...
Are you stupid, Abe? Are you stupid? Is he stupid? I just want to know. And usually state judges are supposed to enforce segregation laws. And this is I'm supposed to say unless they got a typo here. This isn't correct. Unless there is a supervening federal law, and there is, Abe, you were there. It's the Warren Court, Brown versus Board of Education. There is a supervening federal law called Brown versus Board of Education. You silly, burning in hell piece of garbage.
Well, they were convicted under the color of the state law, that is, the disorderly conduct statute of the state, but not because there was any evidence showing a violation of the state statute, but solely for the purpose of convicting and incarcerating these people because the state intended to uphold the segregation, that is, the judge intended to uphold the segregation laws of the state. And if he merely made a mistake of evidence, we would say, no matter how wrong he might be, we would not feel he was liable. But where he does it with the intent, as we say, for the purpose of upholding the laws, we think that spells out the same thing that Senator Trumbull was discussing. The second, I'm sorry, my time is now. Thank you very much.
We got a new brief.
See, when he says we'll get it from your brief, you submit a brief before you go to the Supreme Court of everything you're going to say and everything you're going to argue. You submit the brief to the Supreme Court. He says we'll get it from your brief. Earl Warren's already decided he's going to uphold it because the cops want to impeach him. The cops hate him. In 1967, because of the 1961 case of Mapp versus Ohio that created Fruit of the Poisonous Tree that Clarence Thomas currently wants to overturn Mapp versus Ohio, that makes it so cops have to respect your Fourth Amendment right at home, Earl Warren is facing impeachment by the police, and the police are a giant voting bloc that everybody loves and respects. Whatever the police say is right. And so Earl Warren, what he's saying is we'll get it from your brief, but what he's really saying is we've already decided I can't be impeached. I can't be the only Supreme Court personnel to ever be impeached. So you're going to lose this, bro. We got it from your brief already, but we already decided.
Mrs. Grayson?
Mr. Chief Justice, Subject Justice, with due apology to my opposing counsel, I don't think that this court is placed to argue disputed questions of facts as if they were being argued before a jury. And my position is that that's what opposing counsel has done. They have argued their own testimony or their own complaint, allegations in their complaint, without any reference whatsoever to proof on the other side on what was a jury issue or issues in this case. This is a suit in tort.
It's so ridiculous. It's so... I have to explain this. I have to explain this. I have to explain it. I have to explain what you're listening to here. You have to understand what she's saying right here. She's saying that the jury who convicted the 15 black guys, it's a jury issue. The judge should have looked at the case and said, you guys are enforcing segregation. The case is dismissed and I'm holding the cops accountable. That's not what happened. She's saying it was the jury's fault, not the judge's fault. This was a jury issue. And then she's also saying here that Tenney versus Brandoff can't be re-adjudicated. We can't go over Tenney Brandoff again. We can't do that. We can't question the previous court of 1951, the Vincent court. These questions have already been answered, is what she's saying. And she's going to end up being correct.
Money damages in 2 counts, first under common law for false arrest and second under 1983. First under common law for false arrest. In this case, this is a suit in tort or money damages in 2 counts, first under common law for false arrest and second under 1983. The issues before this court, the jury came in with a decision for the defendant on disputed questions of fact. The issues before this court are not whether those facts were rightly decided by that jury, because it was a jury issue and will go back after this decision to be a jury issue. Regardless of this decision, it has to be replaced and go back for a trial by a jury. The issues in this case are whether or not there is any judicial immunity as a matter of law when there was no proof whatsoever of any corruption or any wrong intent, and whether or not there is a partial or limited immunity to police officers who act in good faith with reasonable grounds to believe, which is a question of fact, with reasonable grounds to believe that the statute was being violated, that they had probable cause, which, as I state, is a question of fact.
No, they did not have probable cause. No one has broken a law. The Fourth Amendment says no warrant shall issue but upon probable cause. They had probable cause, which is a question of fact. No, they did not have probable cause. The sign they put up in front of the diner does not create probable cause because the Freedom Riders went into the diner. That is not how it works. She's pushing the idea that the police officers, what's called subjective intent, if someone wants to put that in the comments right here, subjective intent is correct.
I therefore will only discuss factual issues to the limited extent of pointing out to your honors that there was a disputed question of fact on the right to the police officers to believe that there was probable cause of a breach of the peace. And in doing so, I hope the court will recall and keep in mind that this occurred in 1961. We must look at the facts in the case in view of the times. We must look at the facts in the case in the view of the mood of the people, of the tenseness of the people in the city of Jackson.
So just so you know, if you guys have seen the Overturn Terry part 1, 2, and 3 on this channel, Overturn Terry, I put a clip from 1961 in Jackson, Mississippi. The mood of the people in view of the times, the people of Jackson didn't want to desegregate. They didn't want it at all whatsoever.
In 1961, we must look at the case in the view of what the law was in 1961, how far the constitutional standards have been changed since then.
Ms. Grayson, excuse me.
Yes, Mr. Justice White.
Did I understand you to say that your claim for judicial immunity here stems from the absence of any proof of corruption or evil motive?
I would agree with the counsel that if there was proof that a judge was actually corrupt, that then a judge could be liable. Here, the Judge Myers submitted it to the jury, the judge's immunity along with the policeman's immunity.
Well, now let's assume for the moment that a judge deliberately convicts someone when he knows there is no evidence whatsoever.
I presume that if you could prove that, Your Honor, that I believe that there would be liable.
Okay, it's proven. They went into the diner. They didn't break any laws. They got arrested for no reason. And the Warren Court had already passed the 1954 Brown versus Board of Education that desegregated America. So we can prove that the judge knew better. Of course he knew better. Why are you a judge?
There's no evidence, and he did it deliberately with the intent to hurt that person.
Yes, he did.
If he were mistaken...
So you and Mr. Rackford essentially agree on what the law says?
Except to the extent to which that has got to be proved, I don't, in my own heart, do not feel that judges should be submitted to suits. It would have to be so clear that before they should be submitted to having to defend themselves, the proof would have to be so clear.
It is clear.
Here, Judge Myers thought that he would let it go to the jury, and he did with a verdict for the defendant. The Court of Appeals of the Fifth Circuit said there was no evidence whatsoever, and that it's against the judge, and it should have been dismissed.
May I ask, Mr. Grayson, under what instructions did Judge Myers send it to the jury?
There's no question of the instructions not being
I
followed.
just wondered, what were the instructions?
Now that I can't tell you about them without the record is long, and I don't recall the exact wording of them. But there's been no question raised on either side.
No, but I wondered, did Judge Myers submit it under some instruction that if the defendant judge were found guilty of corrupt or vicious or something like that?
If you are, please, I will have to beg off on that one because I don't recall how that instruction was worded. Just how he submitted
Is the instruction in the record?
But when it went, yes, sir, it's in the record. But when it went to the Fifth Circuit said there was no evidence whatsoever against Judge Spencer. Therefore, that his suit should have been dismissed on the motion which was made after the conclusion of the evidence. I'll please briefly on the facts now, recalling that this is 1961, that the Freedom Riders had the violence in Alabama just 2 months before.
It's Freedom Riders. There's a lot of typos in this. I think a student did this. This is from oyays.org. I think that students did this. There's quite a few errors. But so now recalling
months before, which was made after the conclusion of the evidence. please briefly on the facts now, recalling that this is 1961, that the Freedom Riders had the violence in Alabama just 2 months before. That just a month before this occurred, there had been Freedom Riders in Jackson.
This is supposed to say violence, that the Freedom Riders had violence in Alabama just 2 months before. They had violence. What does that mean? I don't know.
And they had caused almost violence at that time.
And they had caused almost violence. Remember, you're talking to a bunch of racists besides William O. Douglas. You're talking to a bunch of racists. So if you say black people went in and they almost caused violence, well, that's just as good.
The coming of these...
Miss Grayson, just let me pursue this other question
Yes.
just a moment. Let's assume a judge says, well, I agree that the Supreme Court of the United States has decided that case in a certain way, and that case applies to this case, but I think the Supreme Court is wrong, and I'm not going to follow the Supreme Court.
Oh, well, no, sir. I would say there was no liability whatsoever. That's a matter of judgment and a matter of his interpretation of the law.
So that is
That
what
was not...
that is what you're saying.
No, sir.
So
Not at all.
he might deliberately decide to deprive a man of constitutional rights, but that wouldn't make him liable.
No, sir. Not unless he was doing it corruptly. The illustration that Mr.
Did you just see that? I mean, did you just hear it? Did you just see it? Let me just run it back for you again. So he might deliberately decide to try a man of constitutional rights, but that wouldn't make him liable. There's a typo here. To deny a man of, it's supposed to be deny. So he might deliberately try to deny a man constitutional rights, but that wouldn't make him liable.
Deliberately decide to deprive a man of constitutional rights, but that wouldn't make him liable.
No, sir. Not unless he was doing it corruptly.
So you can deny someone of constitutional rights, but you got to be doing it corruptly to be prosecuted as a judge. That's what they're saying back and forth here. And it's not try, he says deprive. He said to try to deprive a man of constitutional rights, but that wouldn't make him liable.
Constitutional rights, but that wouldn't make him liable.
No, sir. Not unless he was doing it corruptly. The
Unless he's doing it
illustration
corruptly.
that Mr. Rockland used would be perfect, where he got together the night before and conspired with one side and said, I'm going to deliberately decide for you and throw the book at him. Now, that might be corrupt, but not a judge differing with the Supreme Court of the Union.
How do we know that the judge didn't meet with the chief of police or the police and say that he's going to throw the book at them? How do we know that didn't happen? We don't. There is no third party to investigate police and judges. So we don't know if they had a private meeting where the judge said he would throw the book at them, and he did.
States or any other court I think is corrupt.
What if the judge says, well, I know the Civil Rights Act of 1964 requires equal service in public accommodation.
Yes. No, I would say not.
And I know that the owner of that the public accommodations refused service. And the judge says, but I just don't agree with that statute, and I'm not going to.
No, sir. I would say that that was his honest conviction of what the law was.
Do you understand how disgusting what you just saw is? Do you understand how disgusting that is? He just said, what if a judge said, well, I'm just going to deny you of rights because I don't agree with that statute? And she said, no, he's fine. Judge can do whatever he wants.
He says, I know what the law is, I just won't follow it.
Well,
Here's the statute, I know that's...
you're getting a little deep. Please, that's a rather serious question that has not presented here whatsoever. This statute not only has never been held unconstitutional yet, under which they acted, under which they were arrested, but the Supreme Court of Mississippi, 2 years after Judge Spencer's decision, affirmed similar cases and made exactly the same decision.
So Judge Spencer, more judges made the same racist decisions, and it was fine 2 years later in 1963. So his racist decision in 1961 should be A-OK.
You couldn't possibly say here that there was any, I know what the law is. The law was valid on his face, under which they were arrested. These policemen, these practitioners in their garb, in their church garb, mixed group, broadcast the fact and planned deliberately to come down to Jackson, Mississippi and to be arrested so they could be what they call witnesses of incarceration and go to Detroit as be witnesses. They came to be arrested. They broadcasted over television, newspapers, that what they were going to do. They came down and drove in taxis to the bus station and went in. And the opposing counsel has now given.
What do we do? What do we do? What do we do today? As auditors, what do we do today? We go down to the library to film, and if they're going to arrest me, then do it, so I can take you to court for violating my constitutional rights of freedom of press. She's saying they intentionally went there to stress test their rights in case they would be arrested, so that everybody could see their constitutional rights were violated. And she's using that against the people. And the judges are eating this up like it's candy. It's just so absolutely disgusting. I don't even know how to properly square what I'm hearing and seeing in my mind with it's just so absolutely disgusting. So I'm going to flip the camera around here. This will be a little easier for me if I do it like this.
The testimony on the other side. They went in and stated, there is testimony that 30 to 40 people followed them in, that they had angry expressions, that they were muttering, and that they followed them.
That they had angry expressions, that they were angry.
To the bus station. This group of churchmen turned in to the left and started towards the restaurant, and the two just beat policemen on the street, told them to move on. They turned back and instead of moving, blocked the stairway in the bus station, stood in this narrow hall, and something the jury didn't need to be told was that that bus station is a very small room, and proceeded to recite the Lord's Prayer. There was a crowd. Not only had 30 or 40 followed them in, but they had there was a crowd in the station. There was muttering, mumbling, wrongful, violent gestures.
Violent gestures.
All three, Mr. Ray and the other two policemen, testified emphatically that they thought that violence was about to ensue and that it would ensue if they did not arrest them. Now, this is not a criminal case on which the criminal convictions would be involved, which would be decided on different principles of law and different bases of proof, where you'd have to prove guilt of such a crime or breach of the peace beyond reasonable doubt. This is a case where the only proof necessary is did those simple policemen standing there on that day with that going on, believing and assuming their own testimony to be true for the matter of this argument, have probable cause to believe that violence was going to ensue.
Okay, listen, there's no such thing as probable cause to believe. This is a misnomenclature that was created in the 1949 case of Brinegar versus the United States. This was created in the 1949 case. Probable cause to believe was created in the 1949 case of Brinegar. And since then, it's repeated hundreds and hundreds of times. I've listened to hundreds of Supreme Court cases.
Grayson, where will we find in the record their statement that they were coming to Jackson?
And they lit up Hugo, and it's Warren talking.
I was pleased I have to find it. In my brief, I refer to, they are a long group of directives or letters which were written to the whole group before they came, in which they were told what they were going to do and how they were going to do it. And those letters go from page 224 on for the next 50 pages. These original letters to these clergymen, to which they said that they were planning which one should go to jail. And at first they said, we think we'll consign 15 to jail and let the rest go on and be with and tell about up there in Detroit what happened. Then there's another letter. They said we think now it's the better part of valor to consign only a dozen men to jail. And then they told in these letters you must stay there long enough without getting bail because you wouldn't be a proper witness of incarceration if you didn't stay there a little while.
So let's talk about that just for a moment here. Let's talk about that just for a moment. So just so you know, And I'm not a member of the black community. Obviously, my skin is white. I'm Colombian. I'm a light-skinned Colombian. My mother's white. So when you talk about what the black culture has had to deal with, they began to take going to jail, especially you can see it in the 80s and the 90s. They began to take going to jail as a badge of honor. You got your street cred. And so back here, what you're talking about is a group of people who are going to go to jail. They know they're going to go to jail. They know that these cops are what they are today. They're the same people that they were back in 1961. And they know they're going to go to jail, so they want to be proper witnesses of incarceration, meaning they want to be able to detail what happened to them once they just had the crime and the audacity to walk into a restaurant and order something to eat. It's if you're an auditor and you're watching and listening to this, this is the most disgusting thing you could possibly hear.
And from about page 224 of the record on, it came from these letters.
Ms. Grayson, I beg your pardon.
Yes, sir.
Do you agree that or do you think that the complaint here stated cause of action?
Yes, sir. There's been no question raised for what the complaint stated the cause of action. We went to trial on the
think
case.
that the complaint alleges the necessary intent or will or attitude on the part of the judge and the policeman?
Well, no question was raised about it at the conclusion.
Do you think that the complaint alleges the necessary intent or will or attitude on part of the necessary intent or will of attitude on part of the judges and the policemen? The sign out front said only white people allowed. We know what the intent was of the policemen. The judge puts them in jail for 4 months. We know what the intent of the judge is.
Is the necessary intent or will or attitude on the part of the judge and the policeman?
Well, no question was raised about it.
Well, no question was raised about it.
The conclusion of the plaintiff's testimony, there was a motion to dismiss as to the judge file, which Judge Miles overruled. And that's what the Fifth Circuit said should have been sustained, because no evidence. But there was no objection made to the complaint or no objection made to the jurisdiction of the court whatsoever.
Well, I must say that reading the complaint, I haven't yet been able to find the allegations with respect to intent.
You silly, disgusting demon. We know what the intent was. It was to uphold racial segregation in Mississippi. You piece of trash.
No, sir. No. But we did not raise the point that the complaint, of course, they sued them all jointly to begin with. The judge could have filed a separate motion, I guess, to dismiss the complaint as to him, but as I recall, no such motion was filed.
You concede that a complaint which does not allege a vicious intent or purpose on the part of the judge or the policeman states the cause of action under the statute?
No, sir, I do not think it does.
Oh my God.
But you nevertheless did not file a motion to...
There was no motion filed until after the conclusion of their evidence to dismiss as to the judge. And may I now state what occurred when they went before the judge. Here was a breach of the peace statute, unlike the South Carolina statute, unlike the Louisiana.
What is the breach of the peace? That the Negro males, the 15 Negroes, went in, they breached the peace by going into a diner and ordering a sandwich. That's the breach of the peace statute that is upheld as constitutional because the sign out front said only white people allowed. This is your qualified immunity case, everybody who hates qualified immunity.
Not vague and indefinite, valid on its face. At that time, the law was final and Canterbury, I believe it is. Cantwell. Those were the two decisions of this court which upheld the Constitution. The final statute was identical with Mississippi statute. It was not unconstitutional on its face. It had never been held unconstitutional and has never to this day been.
It's not unconstitutional to have a breach of the peace statute. It's unconstitutional to enforce segregation using the breach of the peace statute.
Been held unconstitutional, although they insist on referring to it as an unconstitutional statute. It may have been at times unconstitutionally enforced, but
she
never
finally got it.
unconstitutional per se. They were brought before Judge Spencer, and he is ex officio justice of the peace and municipal criminal court, a small city court, criminal court. It's part-time.
He's part-time. He was not a brilliantly trained lawyer. So we should give Judge Spencer a pass for throwing people in jail for 4 months. He didn't have vicious intent when he put him in the dungeon.
He was not a brilliantly trained lawyer. If he was, as I say, the Supreme Court of Mississippi 2 years later upheld the statute and upheld convictions under it.
So is it a shock that the Mississippi Supreme Court upheld the conviction of 15 black dudes? Not at all.
The cases came for trial. All of these petitioners were represented by two attorneys, and I think Mr. Rockland was one of them. There were two, I'm sure, but I think Mr. Rockland was one of them. They had attorneys in court. They could have had a jury trial. They did not request it. They did not testify in their own behalf.
She's using that they didn't testify on their own behalf against them. You think a black guy wants to talk to a white judge in 1961? He does not.
The policeman testified, and these petitioners sat mute. Well, what do you expect a judge to do?
What do you expect a judge to do? To respect the Fifth Amendment, to remain silent. That's what I expect a judge to do. And I expect these tyrants up here who are appointed to respect the man who remains silent in a court of law. That's what I expect out of someone called a Supreme Court justice or called a judge. This is the most, I want to take the stick and pop it through the TV. It just pisses me off to no end.
With a valid statute, the policeman saying he was disobeyed, and the defendants not saying a word. It patently didn't suit that purpose.
This is supposed to say misobeyed, and the defendants did not say a word in painful demonstration at that time. Yes, they're demonstrating their right to eat somewhere under the constitutionality of law. Jesus.
At that time, they wanted to be witnesses of incarceration, and if the judge had let them off at that moment, they wouldn't have been. Then they went on later to the appeal to Judge Moore, and I beg to differ with opposing counsel the fact that the judge said that there was no evidence. The only thing in this record is a record of dismissal with no ground given for it whatsoever, just dismissed. Could have been dismissed on interpretation of the law, it could have been dismissed on insufficient evidence, or as petitioners themselves complained in their letters, they resented the fact that Judge Moore dismissed it because they were Episcopal preachers. They didn't want it dismissed on that ground. So the mere fact that they were acquitted later is apparently what they're saying shows corruption on the part of Judge Spencer.
Yes, that's exactly correct. The mere fact that they were acquitted by the appeals court, right? Because the conviction was overturned, shows that Judge Spencer did something unconstitutional by upholding segregation laws. The segregation laws created by people who claim to uphold the Constitution, the police. So yes, we can see clearly that Judge Spencer is corrupted. He's corrupted. He upheld unconstitutional arrests. The statute of disturbing the peace, a breach of peace, is not unconstitutional. When you use the statute to imprison somebody and violate their constitutional rights, the statute itself is not unconstitutional. The actions of the men doing it are unconstitutional, and those men need to be held accountable. Instead of that, they're going to give the cops qualified immunity.
Just briefly further on the immunity of judges. In this Tenney versus Brandhold, this court went thoroughly into the legislative history of 1983, went very learnedly into it, and came to the conclusion that there was nothing in the legislative history of 1983 to show any intent on the part of Congress to change the common law liability of the tort, to make it anything except a common law tort. I would not purport to attempt to go into the history of that congressional act in 1871 to the extent that Tenney versus Brandhold did. But the basis of the end of their testimony, of their decision as to the legislative history, was there was no intent to change common law tort liability. And of course, the common law tort liability of legislators was immunity. Just as strong is the common law tort immunity, liability immunity of judges. That goes back to Bradley versus Fisher in 80 U.S. 335, where there's a remarkable decision on the necessity for and the reason for and the common law immunity of judges.
Bradley and Fisher wasn't a constitutional decision, was it? I mean, the immunity there was not resting on the Constitution.
No, sir, I don't think so. I don't
45-35. I'm going to fix that.
I don't recall that it was a constitutional question.
Common law immunity.
It was a common law immunity. That's what I say. Tenney versus Brandhold goes back to the common law immunity of legislators.
Right. We read that earlier. You remember? It goes back to the 1500s and 1600s. So because they were immune back in the 1500s, they're immune today. That's what Tenney versus Brandolph said. We read it about 30 minutes ago.
The later cases in every circuit that is passed on it, except the Fifth, including the Fifth Circuit, have held that the same reasoning showed that the legislature's intent was not to change the common law immunity of judges. And there's no reason why it should be, that the intent was not to change the common law tort liability.
It should be changed. 1983, Congress had no such purpose.
Had no such purpose.
Well, what about this language to which Mr. Rockland has referred in the legislative history of the Senate?
He has picked scattered passages from the congressional record.
Oh my God.
I say that if Tenney versus Brandhold went into it thoroughly, and they said there was nothing in the act to indicate any intent to change the common law, that the legislative common law immunity was old, well, so is the judicial common law immunity, and that's the reason I mentioned Bradley versus Fisher, because it is the leading case.
Okay. Let me break this down for you and compare it to Tenney versus Brandolph. Tenney versus Brandolph went thoroughly, and they said there's nothing in the Act of 1871 that created the 1983 a civil rights violation to indicate any intent to change the common law. Then why did we create the act? Who was letting KKK members out of jail? Judges were. The judges were letting the KKK members out of jail. Now, this is where I can add some conceptual analysis for you guys, where you can learn something a little bit bigger. Give me 1 second. So right here, the reason why in 1871, the reason why they created the KKK Act, the reason why that was created was because judges were letting KKK members out of jail. That's where the 1871 Enforcement Act comes from, where it spurns off of, it piggybacks off of the 1866 Civil Rights Act. And then you get the 1871 Enforcement Act that is going to suspend habeas corpus. Roosevelt's going to suspend habeas corpus, Theodore Roosevelt, or Ulysses Grant, forgive me. And so that's where you're going to get it. Of course, they wanted to intend to change the common law by using the 1871 Enforcement Act. So what she's saying is total historical bunk. If you read history and you know history, Tenney versus Brandolph, she's saying the 1871 Act or the 1866 Civil Rights Act, the intent was not to change the common law. That was the exact intent of the law. That was exactly why it was created, because judges were letting KKK members out of jails and prisons when they killed black people. That's why it was created. The entire intent was to change the common law. That's why they created it.
Common law immunity of the judges. Since then, every circuit that has passed on it, the first, the third, second, the third, the fifth, the sixth, the seventh, and the eighth, have all held that Tenney versus Branhove applies to judges. And so we don't need to argue here whether it needs to be complete, absolute immunity or just partial limited immunity, because there was no testimony in this record whatsoever that the judge had ever heard of these people before, that they just appeared in his court, that he had no conversation with any of the policemen about them or anybody about them, that he had any connection with them or any intent whatsoever, or any corrupt intent on his part. So we don't even need absolute immunity in this case. And I would like to hurry on to the immunity of policemen.
I ask you this question. Do you read Tenney versus Branhove as meaning that there is no liability because there's no corruption shown?
As I recall, the case did not discuss the issue that there was actual corruption. Now, when I say, I admit that if there was actual corruption, I mean actual.
Yes.
I don't think that entered into that case any more than it does here. I don't think there was any question.
But a while ago you said that you agreed with counsel that if he had done this thing correctly, the judge would have been liable. Now, do you read Tenney versus Branhove to mean that if Tenney had been corrupt in what he did, that he would have been liable?
If your Honor, please, I read Tenney versus Branhove as merely saying there was no intent to change the common law.
But there was.
Now, if you go back to the common law of judicial immunity, don't you find that exception? If there's actual corruption.
Do we?
I think that would go back to the common law.
Yes.
And all Tenney versus Branhove was saying was that we don't think that the legislative Congress intended to change the common law.
But they did.
So it depends on what the construction of the common law was.
Yes, sir. I think that is the test, is what the construction of the common law was.
Garbage.
And you suggest that the judicial immunity, at least, the common law made an exception to that immunity in cases of the corrupt judge.
I think that it did. I have never felt there was any thought of any corruption in this case and have not carefully briefed that question. Because there's never
felt it.
Yes, Mr.
I was in that case. I never had any remote idea you suggested that there was a word that could lead to the impression that a legislator making a speech, working in the legislative body, could be sued about showing that he was corrupt.
Well, that because you would know better than I do. I don't recall that it was
I'm not
discussed.
familiar with anything in it meant that or said it.
That's what my impression was, that it was not involved, that it was not discussed whatsoever.
What the hell was it is his immunity.
Absolute immunity.
That's right. Absolutely.
Even though corruption.
Now these two are just sucking each other off. Yeah, judges are, totally immune. Yeah, we're totally immune. Totally immune. Yeah. They're just sucking each other off right there in court.
I have no fault to find with the court if they feel that way. I feel better about my client, Judge Spencer. I just had always thought that if there was actual corruption, that the immunity might not go that far.
Even though it did for legislators at common law.
No, sir.
You never thought that it did for judges at common law, or always an exception?
No, sir. I would think that any immunity would
You're leaning a little bit to the side of the dissent in the Tenney case then.
In the what? I didn't understand you, Mr.
I'm talking about my dissent in the Tenney case. Sounds like you're proving.
Leaning that way. But I do say that all the question of corruptness is beside the issue. In this case, we don't have to go that far. We don't have to go whether there be any actual corruptness, because there was none.
Oh, there was no
any
corruption.
evidence of anything except the judge giving his best judgment, which I'd like to get to the immunity of the police officers, because if there's anyone that I feel stand here that needs representation and that I would like to do my best to represent, it is the policeman on the beat in these troubled times.
Oh my God.
When he doesn't know what to do, he has to make snap decisions. He has to...
No. And what do they say now? If you're out auditing and they say, you know, in times like these, it's always been times like these. You're always a victim if you're a cop. You're always a victim. Poor you. In times like these. In times like these. They said in times like these in 1960. In times like these? What you mean? You mean where our rights are violated constantly? And now she wants to hurry up and get to the policeman. She wants to get to the policeman because if anybody needs protection during these hard times, it's police.
He has no lawyer running along his side to tell him what the law is or what the facts are or whether he's right. He can't remember afterwards. Take all this flood in this past summer, the thousands of arrests where policemen have arrested people, where they have thought at the time...
No, they didn't arrest people. They arrest black people and white people supporting black people.
Were justified. Suppose one of those men 3 years later says, well, I was acquitted. The policeman doesn't remember him. He hasn't got down and got witnesses and getting names, getting ready for a lawsuit 3 or 4 years from now. He doesn't know what the fine points of the law. He's got to use his best judgment in whether or not there's violence about to occur. And that is what we submit. That is the common law immunity of police officers.
There it is.
Goes as far.
There it is right there. They believe violence is about to occur, and that is the common law immunity of police officers. It just goes far as back as the immunity of judges. There it is right there. She lays it out.
Is the immunity of judges. If they have reasonable grounds to believe that there's probable cause of violence, then under the common law breach of the peace, they have a right to make an arrest without a warrant.
Oh my God. If they have reasonable grounds to believe that there's probable cause about to be violence, then under the common law breach of the peace, they have a right to make an arrest without a warrant. Nothing has happened. Nobody has done anything. The cop believes that there's about to be violence. So that's why I tell auditors, don't scream, don't yell, talk slow, be quiet, be very cool.
In other words, probable cause is a complete defense to a police officer for a suit for damages at common law. There's no change under 1983.
For a suit for false arrest or...
False arrest,
yes.
Well, that would be true under Monroe versus Tate, too.
Clearly, Monroe versus Tate does not say, it doesn't say to the contrary. It has nothing to do with this case because that was a search and seizure case. And under a search and seizure case, there is no defense of probable cause. They searched the man's house, not in good faith, and also searched it
Without a warrant.
Without a warrant. And for a false imprisonment case, probable cause on the part of the police officer is a complete defense. In an illegal search without a prior arrest, probable cause is no defense whatsoever. When that case was remanded, it was only before this court because the complaint had been dismissed as not stating a cause of action. And this court merely said that it stated a cause of action and remanded it, which I don't think any complaint could came any nearer stating a cause of action than that, but anyone completely stated a cause of action than that one did. This cause remanded it, and they resulted in the district court in a jury verdict for the plaintiff. And then the defendants on motion for judgment notwithstanding brought up that there was probable cause for the search. And the district court dismissed it and said that probable cause is no defense whatsoever. to an illegal search because of the constitutional provision, and that therefore there was no defense whatsoever to that call. There's been no change in that common law rule any more than the immunity of judges in the under 1983.
Yes, there was a change. This is a lie. There has been a change. There's the 1866 Civil Rights Act and the 1871 Enforcement Act. This is a lie. She's lying, and the judges are eating it up because they want judges to have immunity.
On this point, you disagree with the Court of Appeals, don't you?
This is the point under which on which we petitioned cross appeal,
Right.
cross certiorari, on the ground that the Fifth Circuit held that probable cause was a defense to the common law cause of false imprisonment,
But not to the
was
1983.
not to 1983. In the opinion, they merely said that the rule may be otherwise under 1983, and cited no case which is held that it's different under 1983, and yet held that under 1983 probable cause was no defense. And because when this case goes back, we should have a right to submit to that jury again the issue of whether or not those police officers, because the common law controls and still is effective just as much as the police officers under 1983 as it would be the judicial officers. Monroe said that the 1983 must be read in the light of the common law of tort liability.
Monroe versus Pape. If you guys haven't seen that case, it's even more disgusting than this one. That's where they break into a black guy's house with his wife and they strip search them in front of all their kids in the middle of the living room. It's disgusting. Monroe versus Pape would have been overruled by the 1961 case of Mapp versus Ohio. Monroe versus Pape. If someone will please type it in the comments. P-A-P-E. Monroe versus Pape.
It has not in any way changed the common law of what the tort is that they can be sued for. And in this instance, it was false imprisonment. I don't think this court is in any doubt in its thorough brief that false imprisonment is a complete defense at common law. I mean, that probable cause is a complete defense at common law. All that the Fifth Circuit said to support their decision was that inherent in the Monroe holding is the principle that good faith and reliance upon a state statute subsequently declared invalid are not valid as the defense is.
Okay, so what are you looking at here? What you're looking at here is that when they say that Monroe versus Pape is done in good faith, what they're talking about is the good faith of the police, that the police are acting in good faith. Do you follow what I'm saying to you? So this is going to go on, and it's just going to continue to perpetuate absolute nonsense and garbage. But let me just show you the damages. Let me show you the actual human casualty and damages of what an unelected, unchecked, unconstitutional, and absolutely disgusting system of appointing people to the Supreme Court, what exactly it's done. Let me show you exactly what it's done. And I'm going to lay it out in very simple terms here. I'm going to show you guys on a graphic exactly how an unelected Supreme Court has ruined our country. It's ruined our country. So when you go here with unelected Supreme, let me zoom in a little bit for you guys. Sorry about that. Let me just lower these legs down here. There you go. Now I got. Nope, sorry about that. So right here, when you have an unelected Supreme Court, what happens right here in the Dred Scott case? So what does John Jay say? John Jay says in Federalist Paper number 3 that if we appoint the right men in the right places, then it's going to be absolutely great. Right here. I'm sorry, right down here. So in the 1857 case of Dred Scott, this is where the unelected Supreme Court says that Dred Scott's not a man, he's a piece of property, and that kicks off the Civil War from 1861 to 1865 here. And then when the Supreme Court in Cruikshank says that we can't enforce you having civil rights, that's going to kick off the lynching chart. And you're going to have lynchings for decades and decades and decades because an unelected Supreme Court said that the federal government didn't have to enforce your civil rights. It's absolutely horrific. Lone Wolf versus Hitchcock, this is the case that actually wiped out the Native American Indians. This case, Lone Wolf versus Hitchcock, you could go back into a lot of things, into the 1860s and the Trail of Tears and all that stuff, but the case that truly broke the Indian tribes was the 1903 case of Lone Wolf versus Hitchcock. And what did that do? That decimated an entire race. An entire race was wiped out because of Lone Wolf versus Hitchcock. And then your resisting arrest charge comes from Bad Elk versus the United States in 1900. This is still on the books today. How many people today are arrested for resisting arrest? Bad Elk is still law today. Carroll versus United States, an unelected Supreme Court is going to create the edges and circumstances clause. That if there's going to be a loss of life, if the cops are in hot pursuit of you and they need to seize evidence, well, then they can exclude your rights and search your car without a warrant. You follow? So the unelected Supreme Court is what has decimated our country and ruined a free America. So now listen, there's about 20, 30 more minutes of oral arguments where she's just going to repeat back and forth, and they're pretty much just going to I don't want to be vulgar, but they're just going to kiss each other's butts over and over and over and say how judges and legislators get immunity. And then, of course, the case ends without any resolution because Supreme Court justices are cowards. They write their decision later and then they announce their holding that you and I now have to live up to if we're going to be legal citizens and follow under a rule of law underneath of the social contract. And this is how our country is ruined. This is how our country is ruined. This is how the country is ruined. So there it is, guys. There it is. I really don't have much more to add. I'm doing that one meal a day thing. I'm doing that one meal a day right now. So I'm absolutely starving. I'm gonna die of hunger here in a moment. So I've got to stop. We've been on for almost 3 hours or something like that. So I got to get out of here. Thanks for coming by. Appreciate everybody coming by. As you guys know, I look forward to speaking to you guys. Let me try to put a light on here so you guys. Well, I see, there it is. Everything's messing up for me. So that means it's probably time to go, you know, and plus it really ticks me off. It really pisses me off. It pisses me off. This kind of stuff goes into my head, and listening to her say, well, you know, we didn't plan on changing common law. Well, then why was the 1866 Civil Rights Act created? Why was if we didn't plan on changing common law from the 15 and 1600s, why did we create the 1866 Civil Rights Act and the 1871 Enforcement Act, where you get the 1983, the civil rights violation when you violate my rights using the color of law, that any person can be held liable. But then they just create exceptions for that. They just created exceptions for it. Anyway, thanks for your support, guys. I appreciate it. If you guys don't have an ebook or poster, please go by my website, deletelaws.com with a Z, deletelaws.com with a Z. You guys can get my poster right down here. Let me just get this thing straightened out for you guys so you guys can see it. This is my website right here. You can go to deletelaws.com to get this exact poster. It's deletelaws with a Z. If you learn anything from me at all, feel free to pick me up a cup of coffee. Don't break your own bank account here. I'm talking about a cup of black coffee. Not a latte, unless you're flush, baby, and you're rolling fat, because I'm not. But you're more than welcome to buy me a cup of coffee right here. These are my cup of coffee funds. Feel free to buy me a cup of coffee if you would like to, or pick up my ebook or poster on deletelaws.com with a Z. If you can't afford a poster, just send me an email to deletelaws@gmail.com, deletelaws@gmail.com, and I'll send you a poster 100% for free. Okay? You don't have to pay for it if you don't got any money. Dude, listen to me. I've been an executive in my life where I'm making $250,000 every 2 quarters, and I have been so poor that I couldn't afford a bus ticket to get on a bus to go from one block to the next city. So I've been on both sides of the spectrum. That's why I'm just like, if you want a poster, man, I'll just give it to you. It's digital, so you have to go print it out when you save up $15 from Vista Prints. But I've been there where I didn't have $15 to go print up my poster at Vista Prints. I remember one time, I got a really rich buddy, went to Yale, graduated valedictorian from Yale, and he called me up, and at this time, I was so broke. I remember I was so broke. And he was like, hey, Chili, I'm having a party, which is I'm going to go to a really rich guy's house in the Hollywood Hills, this beautiful, beautiful house. You have no idea. And he says, can you do me a favor and just stop by the store and pick up, maybe 10 bags of ice? That's what he said to me. And I remember not having the money. I remember not having the money to do it. I remember that. I remember that time, So don't think it's an inconvenience for me to give you a poster. It's digital. It takes 5 minutes of my time, and I don't mind doing it. So if you don't have a digital poster, you don't have an ebook, and you don't got I lowered the price, by the way. I said I was going to lower the price to $20, and I did. I lowered the price of the ebook. I lowered the price of the digital posters to $20. I also put up there for people who want to contribute. I put a $50 ebook and a $50 digital poster. They're exactly the same. They're exactly the same poster. The same poster. The same poster I give to someone for free is the exact same poster you can buy for $20, or the exact same poster you can buy for $50. Okay, so there it is. There it is. Okay, cool. Any questions at all? Anything? I can't really answer any questions. My head is a rock, and I got to get some food in me right now. So cool. Listen, thanks for coming by, guys. I really appreciate it. I really love talking with everybody, and I'm getting tons of emails. Make sure Brookside people from Alabama keep sending me your contact information. I'm extraordinarily busy all the time. I woke up this morning and someone had been arrested, or someone was on the run for a warrant, and I'm working just 24 hours a day, 7 days a week. Shipping those t-shirts yesterday was such a relief off of my mind. So anyway, cool. I hope you guys, and by the way, I hope you guys are making friends in the comments. I hope you guys are connecting with one another. And thanks for your time. I really appreciate it. God bless you. God bless the United States. And remember, we only have our rights if we fight for them. So welcome to the Overturn Terry team. Overturn Terry, baby. Overturn Terry. TAC is coming. TAC is coming. All right, talk to you guys soon. All right, we'll see you soon. Later.